Hi everyone, my name is Bazikyan from Bazikyan Law Group, and this month I wanted to discuss corporations and how you should treat them with respect to your estate plan. So what happens to your corporate interests when you pass away or become incapacitated? We've kind of discussed the different types of corporations in previous videos, so in this one I want to focus on addressing what happens when you pass away or become incapacitated to your shareholder interest in a corporation. So previously we talked about John and his dog grooming business. So let's say, for example, John has a dog grooming business, and instead of an LLC, he decided to operate using a corporation. The type of corporation is irrelevant here. The fact is that he has set up a corporation, which is a type of business entity, and the corporation owns the dog grooming business, and John owns the corporation. So he has shares of stock in this corporation, and he might be the sole shareholder. So let's say, for purposes of this example, he is the only shareholder in this corporation. He owns all the shares of stock. So what happens when John is actually incapacitated or when he passes away? Same thing that happens with anything else that you have that's an asset. It'll get probated. So if John passes away, just like his home, for example, this corporate interest would go through the probate court system before it's actually distributed to his loved ones. So for example, he has a wife and kids. Before his wife can actually jump into the driver's seat of this business and take the reins and start running it and continuing to make a profit or whatever he was doing, she's going to have to go down to the court, ask a judge to give her permission to come back and run the show. And this entire process can take several months. So essentially what's going to end up happening is the business is likely going to be at a standstill of some sort until somebody is placed in charge legally, until somebody, and in this case it's probably going to be his wife, is able to obtain the authority to sign on his behalf, on the behalf of his estate. So before she can actually go into his bank account for the corporation and sign things off and transfer and continue doing business, she's going to need that power to sign, and in order to get it, she's going to have to go down to the probate court, and we all know that that's a lengthy process, so it's going to take a couple months. So the business is really going to be at a disadvantage and could actually be potentially harmed by this event. Similarly, if John was disabled for some reason, mentally or physically, the same result would happen. She would have to go get a court conservatorship over him to be able to act on his behalf. So just like any other asset we've discussed in the past, just like your home that you would put into a trust, your corporate interest, your shares in your business, your corporation should also be transferred into your trust. Now, there's certain corporate interests that cannot be transferred, or if they're transferred into a trust, need special language in the trust. And these would be corporations that are for professionals. So if you have a professional corporation, like you're a doctor, you're a pharmacist, you're an attorney, be very careful, because your trust needs to be designed in a very special way that takes into consideration all the professional requirements that you're obligated to fulfill as a professional licensed by the state of California. So at the end, the takeaway from this video for you should be, if you have a corporate share, or if you're a shareholder in a corporation, whether you're the sole shareholder or in there with other partners and other shareholders, you all need to make sure that your shares of stock are in a living trust and you have an estate plan in place. So similarly, if you are a co-owner of a business and you've used a corporation, your partners that are your shareholders, the other shareholders, you better make sure that they are also protecting their shares, because if they pass away, it puts you at a disadvantage, because the entire business comes to a halt, or it slows down, or it's disadvantaged to some degree. So the takeaway would be to make sure that you have transferred your shares of stock in a corporation into your trust properly, whether that's a professional corporation, an S corporation, or a C corporation, and make sure you have an estate plan that takes into account these types of assets. If you would like to sit down with me and discuss the situation more particular to your needs, feel free to contact our office. We provide free consultations. Thank you. Bye-bye.